Good afternoon, everyone. This is Glenn Tate from the Law Society, and welcome to today's session on environmental liability for directors and officers. Today's session is going to be put on by Julie Abouchar and Chuck Birchall, both of Willms and Shier. Sorry, guys. I want to talk a little bit about Willms and Shier, and because I really appreciate them putting on this session today. Willms and Shier Environmental Lawyers is one of Canada's leading environmental law firms. They've been in operation for over 40 years, providing advice with respect to a full range of environmental, indigenous, and energy and natural resource issues. They have 17 lawyers in their 4 offices in Calgary, Toronto, Ottawa, and Yellowknife, 5 of which are members of our bar. And with 17 lawyers, that makes them the largest private sector environmental law practice in Canada. Presenting today will be Julie Abouchar and Chuck Birchall, both of which are partners at Willms and Shier. Julie is a certified specialist in environmental law and Indigenous legal issues, rights and governance, and corporate and commercial law by the Law Society of Ontario. And Chuck is also certified by the Law Society of Ontario as an environmental law specialist. Between them, Chuck and Julie have over 50 years experience in this area, and we're very grateful to have both of them here today. And without anything more then, I will, with one more thing, I will turn it over to Julie and Chuck. A reminder, please keep your mics on mute. If you have any questions, can you ask them through the chat function? And I will then interject and drop the questions in an appropriate time. We are recording this session. It will be posted on the Law Society's YouTube channel afterwards. And Julie and Chuck have provided quite an extensive list of articles and cases that they're going to be referring to. We will get that circulated to you as soon as the Law Society is back in business. Those of you that are residents will know that we are closed presently as our carpets are being replaced. So we'll get that circulated to you, and we'll also have that posted with the posting of the recording of this session. So without anything more, Chuck, over to you.
Thank you, Glenn, for that very kind introduction. Good afternoon, everybody. Julie and I really do wish we were in Yellowknife and not sequestered in other parts of the country. But we're grateful to have this opportunity to chat today about officers and directors' liability. As you know, environmental legislation imposes personal obligations and risks on directors and officers of corporations, and officers and directors' liability for climate change related issues is also emerging as a trend. So today, Julie and I are going to be discussing the scope and extent of directors and officers' exposure to environmental liability, and how the expansion of that scope and extent of liability in Ontario particularly may be an indicator of where things are heading in other parts of the country, particularly the Northwest Territories. We're also going to talk about best practices for mounting a due diligence defense, good governance steps related to climate change related risks, and other steps to provide protection from personal environmental liability, such as directors and officers' insurance and indemnities. So for those of you in private practice, we anticipate that with this topic, you might be thinking that identifying environmental risk could be a clear signal to, or impediment to real estate and corporate commercial deals getting done. On the contrary, our purpose in talking to you about environmental risk today is so that you can better assist your clients in doing their deals, so you can assist them in understanding the risks, so that the clients can make informed decisions about whether that environmental risk is within their risk tolerance, so that you can assist your clients to manage environmental risks that have been identified, and how to handle new environmental risks that may be coming their way. And lastly, we want you to consider, the fact that you're going to be avoiding liability that might accrue to you if you fail to talk to your clients about the environmental risks associated with their businesses. So, under Northwest Territories Environmental Protection Act, as many of you know, the ENR has the authority to order various persons to take steps where there's been a discharge of a contaminant. This legislative mechanism is known as the polluter pays principle. Under subsection 4.1, the Chief Environmental Protection Officer, where he or she is of the opinion, based on reasonable grounds, that it's necessary or advisable for the protection of the environment to do so, he or she, by order directed to any person, may require that person to A, install safeguards to prevent the discharge of contaminants into the environment, B, to site, transport, or store any contaminant in the manner set out in the order, C, to have on hand at all times the equipment and material necessary to alleviate the effect of the discharge of contaminants. So the reference to any person in that subsection can include an officer or director of a corporation. Subsection 4.2 of that act provides that where an inspector believes on reasonable and probable grounds that a discharge of a contaminant in contravention of the act, the regulation, or the provision of a permit or license is likely to occur, the inspector may issue an order requiring any person whose actions may increase the likelihood of that discharge, or the owner or person in charge, management, or control of the contaminant to take preventative measures. Subsection 6.1 of the Act speaks to the inspector being able to issue an order where the discharge of a contaminant has occurred or is occurring. And again, the owner or person in charge, management, or control can be subject to that order. The courts in the territories have not interpreted yet what charge, management, and control might mean under the EPA. However, in Ontario, courts have provided guidance on what charge, management, and control means in the context of similar provisions. You'll find going across the country that the provisions are remarkably similar when it comes to directors and officers' liability. Under case law in Ontario, officers and directors are presumed to have charge, management, and control. And lastly, in terms of sections that I'm going to be quoting from the Northwest Territories EPA, section 7.1 provides that where a person discharges or permits the discharge of a contaminant into the environment, an inspector may order that person to repair or remedy the injury or damage to the environment that results from the discharge. As in Ontario, this section of the EPA could be interpreted by the courts to mean that there is a presumption that a corporate director or officer has management or control and thus could be considered to have permitted the discharge. So while NWT legislative provisions have not been substantively considered by the courts in this regard, Julie's going to review some cases with us relating to similar provisions in Ontario under its Environmental Protection Act to illustrate the potential scope and extent of DNO liability. Julie.
Thanks, Chuck. ROCA, I'll review some cases as Chuck mentioned. The first is known as ROCA. ROCA is an environmental review tribunal decision from 2015. Mr. Roca was a business advisor, accountant, and mortgagee of a business in Oakville. The property was the site of trichloroethylene contamination. In Ontario, the equivalent of the ENR is the Ministry of Environment, Climate Change and Parks, or MECP. An MECP order required Mr. Roca to conduct off-site indoor air sampling and TCE plume delineation. Mr. Roca appealed the order and argued that he was not a person with management or control of the property. Mr. Roca lost. The ERT decided that Mr. Roca had both management and control of the undertaking or property under the EPA, under the Ontario EPA, that's section 157.1 sub 1, if you're interested. The ERT held that Roca's management of environmental issues at the property overlapped with his financial control, and that it was his management decisions that led to inaction in addressing contamination. McQuiston is a decision, another decision by the ERT. This one was from 2016. It was about a cleanup order issued by the MECP. Note that Ontario's EPA specifically allows the MECP to issue a cleanup order against current and former owners and occupants and persons who have or had management and control. In contrast, the Northwest Territories EPA, Section 7.1, provides that cleanup orders can only be issued to a person who discharges or permits the discharge of a contaminant. In our view, a corporate director or officer with management and control could be presumed to have permitted the discharge of a contaminant. In McQuiston, an abandoned industrial site was the source of solvents draining into a local watercourse and ultimately into Lake Ontario. The MECP issued a cleanup order against a whole list of individuals: the former tenant of the abandoned site, the former tenant's site manager, the office and directors of the former tenant, one of whom was approximately 81 years old, in poor health and possibly bankrupt, the numbered company, who was the current owner of the abandoned property, the British resident who inherited shares in the numbered company property owner from his recently deceased father. The British resident was also the sole surviving director of the numbered company property owner, the accountant who was given power of attorney for the sale of the abandoned property, the real estate broker who listed the property for sale and was named on the waste manifest as the key holder of the lockbox, and finally, two individual directors of the listing broker's realty company. In this case, the accountant applied for a stay and was relieved of compliance, provided that the property owner complied with the order. Interestingly, the accountant said he was prepared to launch a charter challenge of the order against him on the basis that the ministry's enforcement action deprived him of his right to do his job. In 2016, the director revoked the order against the real estate brokerage and its two directors, and the ERT dismissed the proceedings against the real estate brokerage. The case was dismissed against the realtors on the basis that the order was fully complied with by two other parties, the British director and the property owner. Both the real estate brokerage and its two directors failed to file their appeals of the order. The order was settled by our clients, who were the property owner and the British resident sole surviving director, on the basis that some environmental management work would be undertaken, which was much less than what the ministry's order had contemplated. That said, the settlement did involve fairly substantial work and expenditures on their parts. Another environmental order case involving personal liability is Elizada. Elizada is a July 2019 Environmental Review Tribunal decision. In this case, the ERT confirmed that directors and officers of a corporation are presumed liable when personally named in an EPA order. Note that this case is all about a former director called Grant Ehrlich. Let's start with some facts. The company purchased a wood waste landfill site. In 2013, the ministry issued an order requiring the company to conduct work on the landfill and leachate collection system. The company did not comply with the order, so the company and Ehrlich, its former director, were prosecuted. The company was convicted and fined. The charges against the former director Ehrlich were withdrawn. A court order was issued requiring the company to complete the construction of the leachate collection system by a set date. The ERT noted that the company did not complete the court-ordered work, and leachate from the landfill continued to discharge to groundwater and surface water off-site. In March of 2018, the ministry issued another order against the company. The second order also named the former director Ehrlich personally. Just in interest of full disclosure, we are currently acting for the company and two of its directors concerning the charges laid by the MECP. However, we did not act for Grant Ehrlich or any other party in connection with the ERT case that I'm describing. The order required the company and Ehrlich to inhibit migration of the contaminants. The former director Ehrlich argued that the order improperly named him for two reasons. First, he was never a person in management or control of the company. And second, he had no financial ability to comply with the order. The ERT rejected these two reasons and dismissed Ehrlich's appeal. The ERT confirmed that corporate directors and officers are presumed to have management and control of the company. In doing so, the ERT referred to holdings from previous ERT decisions. For example, in Roca, the ERT held that control includes both the power to make things happen and the power to prevent things from happening. In Curry, the ERT held that a director who acts as a point person to the Ministry of Environment and has knowledge of the environmental issues at the site has management and control. In Caltex, the ERT held that the onus is on the officer or director to present convincing evidence to rebut the presumption of management and control. In Elizada, the ERT stated that management and control is not limited to formal legal control by officers and directors. It also includes de facto control. The ERT said, where those with formal legal control of a corporation deny their involvement, the tribunal puts the onus on them to make a convincing case. In this case, the ERT concluded that the former director Ehrlich had not led sufficient evidence to rebut the presumption of control. This was despite the fact that Ehrlich was not a director at the time of the order, had no access to any corporate documents that might prove his position, had no access to the site to comply with the order, and was even prohibited by court-ordered bail conditions in an unrelated matter from contacting the other director to obtain access to the site. But these factors were insufficient to rebut the presumption of control. The ERT instead cited the following factors to conclude that the former director Ehrlich did have management and control. Publicly available corporate filings indicate that Ehrlich was the only director for much of the relevant time period. Ehrlich negotiated and signed the agreement of purchase and sale for the property on behalf of the company. Ehrlich signed contracts on behalf of the company for work to be done on the leachate treatment system. For 5 years, Ehrlich held himself out to the MECP as the only person making decisions about leachate management on behalf of the company. Ehrlich made commitments to the MECP and the company that the company would comply with the order. And the company's environmental consultant took instructions from Ehrlich. Ehrlich argued that all his actions were done at the express direction of another director. To support his argument, Ehrlich presented a letter from the company's environmental consultant stating that he, Ehrlich, did not hire or instruct the consultant. However, the ERT held that this letter was insufficient to rebut the presumption of management and control. And the ERT concluded that former director Ehrlich had management and control. Elizada affirms the ministry's and the ERT's belief that the evidentiary burden to rebut the presumption of management and control is extremely high. As for the second issue, the ERT affirmed that financial hardship is not a reason to remove a director's name from an order. 3 notices of assessment from the CRA showing that Ehrlich had limited income were insufficient to warrant removing the director from the order. Ehrlich argued that the ministry should use the financial assurance provided by the company to pay for the completion of the leachate treatment system. The ERT rejected this argument. The ERT concluded that the financial assurance was not intended for this purpose. Using it to construct the leachate system would mean there would be insufficient funds to maintain the system in the future. The ERT also noted that when the company had purchased the property, the vendor advanced funds to the company to be used to construct a leachate treatment system. And under the former director Ehrlich's oversight, these funds were not used for that purpose. And the ERT said that it was insufficient for a director or officer to provide reasons for their removal of their name from the order, without also addressing how environmental protection objectives of the EPA will be met if the order is revoked. When we last checked, no application for appeal of this ERT decision had been filed. Takeaway from this case is that directors face an uphill battle to show that they do not have management or control. Directors and officers will be liable for orders without strong evidence rebutting the presumption of management and control. And financial hardship in complying with the order is unlikely to get them off the hook. In contrast to Elizada, and to elaborate on this issue of financial hardship, I want to briefly discuss a case where the orderee, the Rubens, simply did not have sufficient funds to comply with an MECP order, and the MECP had nowhere else to turn. From the late 1950s to 1990s, Harry Rubin and Son Limited operated a metal recycling business in St. Catharines, Ontario. In the 1990s, under MECP director's instructions, the company had PCB and other waste transported to and stored at its facility in Thorold, Ontario. In 2012, the MECP director alleged that brothers Alan Howard and Ronald Rubin had management and control of the waste stored at the Thorold property and ordered the Rubens to remove and dispose of waste stored at the property, including PCB waste, and provide financial assurance. The MECP director relied on the fact that the Rubens were former directors and officers of the company in issuing the director's order. The MECP director also named the company, now owned by a trust, and the trustee of the trust. The Rubens appealed the director's order to the ERT. The company and the trustee, who vacated her position, did not appeal. Over 4 years, our firm assisted the Rubin brothers in their appeal of the MECP order. We appealed it to the ERT. The Rubens produced information about the origins of the waste and requested that Horizon Utilities Corporation and the City of St. Catharines be included in the director's order, and that they undertake the waste removal work. The tribunal reviewed the financial hardship of the Rubens, who could not afford to complete the entirety of the work ordered. They simply didn't have enough funds to do the work ordered, not as an issue of fairness, but rather as a practical issue of completing the work. The tribunal took a pragmatic perspective and held that the natural environment cannot be protected if the MECP or a director orders a party who doesn't have the financial capacity to complete the work. In what was a very rare outcome, Willms and Shier assisted the Rubens to settle their appeal with the MECP before proceeding to a full hearing. In the settlement, the Rubens were removed from the order. The MECP director issued a new order to the Rubens with a narrower scope that will not result in undue financial hardship to the Rubens. And the MECP in turn released the Rubens. The MECP rarely provides a release to orderees from any future liability relating to the property. The Rubin decision may open the door to appeals of orders based on undue financial hardship, where there is an alternative solution that can achieve environmental protection. But the takeaway from Elizada still stands. Directors and officers face an uphill battle to show that they do not have management and control.
So just to pick up, so we've been talking about the regulatory orders. There's also the issue of prosecutions. Under several Northwest Territories environmental statutes, where a corporation commits an offense, quotes, any officer, director, or agent of the corporation who directed, authorized, assented to, acquiesced, or participated in the commission of the offense is a party to and is guilty of the offense, whether or not the corporation has been prosecuted. I've just recited part of section 14.1 of the EPA. 14.2 goes on to provide that no person shall be guilty of an offense if the person establishes that he or she exercised all due diligence to prevent its commission. But more about due diligence later. There are other NWT examples of director and officer liability. There's the Species at Risk Act, Section 121, the Protected Areas Act, Section 77, the Wildlife Act, 151, and the Waters Act, 82. There are also comparable D&O liability provisions under federal statutes. For example, the Fisheries Act, 78.2, the Mackenzie Valley Resource Management Act, 144.1, point 14. These statutory provisions have not been judicially considered, however, with one exception. The exception is the Fisheries Act, Section 78.2, which has been considered a handful of times and once by an NWT court in R versus Beaulieu. For those of you who are not familiar with that case, the Yellowknives Dene Nation, the Detton-Cho Corporation, and Mr. Beaulieu, the elected chief of the First Nation and chief executive officer of the Detton-Cho Corporation, were all charged with carrying on work that involved the deposition of soil or debris into fish habitat, thereby destroying fish habitat and depositing a deleterious substance into water frequented by fish, contrary to the Fisheries Act. The First Nation, Beaulieu and Detton-Cho Corporation submitted an agreed statement of facts to the court admitting that some person or corporation had deposited blasted rock, soil, and other vegetative material and various debris from a housing construction project at the edge of land that abuts Back Bay. The area was flattened by a bulldozer and the deposit of material was pushed out into the bay, covering a flooded grassy and marshy area along the shoreline. The evidence suggested that the corporation was responsible for the fill operation, and the trial judge concluded that Mr. Beaulieu managed and directed the corporation, and that Beaulieu, 1, actively participated in all of the events by making site assessments and decisions, and 2, issued directives that showed that he was effectively in charge. The trial judge convicted the First Nation, the corporation, and Chief Beaulieu. The First Nation, corporation, and Beaulieu appealed. On appeal, the Supreme Court, the Northwest Territories Supreme Court, held that because Beaulieu was the CEO of the corporation and was directly involved in the fill operation, that section of the Fisheries Act was triggered, and the conviction against Chief Beaulieu was properly entered. He was ultimately fined $3,000 for his role in the offense, but the case stands for the proposition that demonstrates how directors and officers directing the actions of corporations can be held responsible. So, due diligence defense. How can directors and officers minimize their exposure to environmental liability? Remember section 14.2 of the EPA, which absolves directors of responsibility or liability where they can establish a due diligence defense. It provides threefold benefits. 1, it can be a complete defense to the prosecution. 2, it can assist in the mitigation of the penalty or fine. And 3, it can protect against situations that give rise to ministry orders or department orders and also civil claims. The primary way for directors and officers to respond to a prosecution is to establish this defense of due diligence. It requires that the company or director or officer establish that they were diligent in their environmental management and overview of the company's operations in a way that would prevent environmental harm. How is this proven? It helps if the director or officer can point to an environmental management system or some steps taken to become informed about environmental issues and steps that can be taken to ensure that there is no environmental incident. An EMS or environmental management system can help to prevent situations that give rise to ministry or department orders. It's not a defense because there is no defense to an order, but the EMS can prevent situations that can cause orders to be issued. Given the difficulty or challenge of establishing a due diligence defense, and given that many directors and officers do have management and control, what other steps can be taken to protect officers and directors from environmental liability? Well, I want to spend a bit of time on a case called Control Chem. It's not reported, but if you, at the end of this, Glenn was saying we will make available all of the cases, the citations that we've referred to. And there are a couple of cases that have not been reported. If you'd like the case decision, we'd be happy to forward it to you. Just let us know. In Control Chem, an employee of a chemical company working in Oakville deliberately discharged liquids from 4 large totes into a storm drain, which turned a creek white. Charges were brought against both the company and the employee. The employee pled guilty and was convicted of 1 charge. The company made out a total and complete defense to its charges. The court found that the company didn't authorize or permit the employee's rogue discharge. In fact, the company had a well-known mantra of nothing leaves the building. Unlike civil claims or regulatory orders, the company was able to tender a due diligence defense. The due diligence defense required the defendant to show that it took all reasonable steps to avoid the offense in question. The cases tell us that superhuman efforts are not required in making out a due diligence defense, but in this case, the company established a due diligence defense and was acquitted of all charges. We represented the company in that case, and interestingly, the employee who dumped the contaminants into the storm sewer, he'd actually taken a course. He'd gone through some training just a matter of a couple of weeks before this happened. So we never did know why this employee did what he did, but the company was able to establish the due diligence defense. The indicia of that defense included 1, ISO 9001 and ISO 14001 certification. It was an early adopter, written environmental policies, standard operating procedures, documented training, identification and remediation of deficiencies in operating practices, periodic external audits of practices and procedures, and the company mantra, nothing leaves the building. This is an example where the Crown made all elements of the 5 offenses involved, but the accused was able to avoid conviction based on the due diligence defense. I want to spend a minute or two about indemnities. Both the Federal and Northwest Territories Business Corporations Acts allow for corporations to provide indemnities for their directors and officers for all costs, charges, expenses, including settlements or judgments for any civil, criminal, administrative, investigative, or other proceeding that the director or officer is involved in because of their role as a director or officer. BCA's, Business Corporations Acts, limit this indemnity to those situations where 1, the director or officer acted honestly and in good faith with a view to the best interests of the corporation, or where it is a criminal or administrative action or proceeding, the director or officer had reasonable grounds for believing that their conduct was lawful. So, this will provide limited protection only where a director or officer is found guilty of an offense under a statute or required to comply with an ENR order. But from a practical standpoint, where the corporation is no longer active, it's unlikely that there'll be any funds available to indemnify directors and officers. I want to spend a minute on insurance. You should know that directors and officers' policies do not usually respond to environmental matters. Directors and officers' policies almost never contain pollution coverage. Directors and officers' policies usually provide coverage where the company defaults in indemnifying directors. And directors and officers' policies usually respond where the director or officer has committed, quotes, a wrongful act. The problem with the wrongful act requirement is it puts the director in a bit of a bind when it comes to the director's defense to a prosecution or appeal under an order. Insurers have been working on new products designed to protect directors. We do provide advice to insurers, and to in our experience, we've yet to see anything that's really worked well yet on that front. So the bottom line for lawyers, for us, is to ensure that our clients record in writing and that we record in writing that we've advised our clients about these potential risks of environmental liabilities, and that in telling them and noting that environmental personal liability is a real threat for officers and directors, professionals, and anyone who can be alleged to be in management or control. Environmental liability in Ontario is expanding, and Julie wants to highlight a couple of cases.
Right, so picking up where Chuck left off about the concerns around environmental liability, how big a concern is this really? We want to highlight some cases that show the scope of environmental liability and how it has expanded in recent years. These cases are not directly applicable to the current Northwest Territories legislation. However, they highlight a trend of expanding environmental liability and may be an indicator of where things could lead in the Northwest Territories. So the first case to discuss with you is known as Kawartha Lakes. When it comes to an MECP order, this case is the case that shows that you can be held liable even for contamination that you did not cause. In the Kawartha Lakes case, the ministry issued to the municipality of Kawartha Lakes an order to clean up a fuel oil spill. The spill occurred at a residential property adjacent to the municipal lands. The contamination flowed through the municipal property and contaminated the neighboring lake. The municipality appealed the order to the ERT. At the ERT, the municipality argued that it wasn't fair for the municipality to be ordered because it did not cause the spill. The situation that this municipality is in is effectively being a flow-through property. The oil flowed through and beyond to the lake. They argued that that wasn't fair, but the ERT held that fairness wasn't relevant and would not relieve the innocent municipality from the order. Since the municipality could not provide a solution that would protect the environment if that municipality were removed from the order was upheld against it. Though not a case involving directors and officers, it is important to note that fairness and fault will generally not be considered by the Environmental Review Tribunal as a reason for the ministry to not include a party in an order. So let's talk a little bit about another non-polluting orderee. In Hamilton Beach, the Environmental Review Tribunal confirmed that the ministry has jurisdiction to make an order requiring a person who owns or owned or who has or had management and control of a contaminated undertaking or property to delineate contamination that had migrated off-site from the source property. This case involves a contaminated property in Picton. During the 60s and mid-70s, the property was owned by a predecessor of Carillon and was leased to Proctor Silex. Proctor Silex operated an appliance manufacturing business at the property. During Proctor Silex's tenancy, the property was contaminated with TCE, tetrachloroethylene, and its degraded byproducts, dichloroethylene and vinyl chloride. In the years that followed, the property was sold to DeRocco, who ultimately transferred ownership of the property to a numbered company that he owned and controlled. Hamilton Beach took over the tenancy of the property from Proctor Silex in an asset purchase in 1983. Contamination at the property was discovered in 2008. and the contamination had migrated to a neighboring residential, commercial, and industrial properties. The ministry was concerned that the contamination might be entering neighborhood buildings by way of vapor intrusion. The ministry issued an order under section of the EPA, section 18, to Hamilton Beach, who was the tenant, Carillon, who was the former property owner, the numbered company, who was the current owner, and Mr. DeRocco, who was also a former owner, as persons who own or owned or have or had management or control of the property. None of these parties named in the order are or were the polluter. The order required the parties to investigate and delineate off-site contamination. The orderees argued that the ministry did not have jurisdiction to make this order on the basis that it required off-site work only. The ERT concluded that the director has the jurisdiction to make the order. The tribunal held that the director can make an order requiring a person to deal with an existing and ongoing adverse effect, and the contaminant does not have to be on the orderee's property at the time the order is made, and that an order is not limited to requiring work on site. Put another way, an order can exclusively be for off-site work. However, the tribunal stated that the question of whether prior owners can be ordered to undertake off-site remediation can only be addressed if and when such an order is made. This particular case was an order to delineate, not to remediate. The orderees appealed to the divisional court, and the divisional court disagreed with the orderees and held that the ERT decision met both standards of reasonableness and correctness. The orderees sought leave to appeal the divisional court decision to the Court of Appeal. In December of 2018, the Ontario Court of Appeal denied leave to appeal from the divisional court's decision, and the Court of Appeal upheld the ERT decision, which in turn upheld the ministry's order in Hamilton Beach. The upshot is that ministry orders for off-site investigation are lawful, even where the orderee does not have any association with the polluting activity other than the orderee's ownership and or occupation of a contaminated source property. So we would also like to touch on statutory causes of action. Under the Ontario's Environmental Protection Act, there is a civil statutory cause of action for compensation related to spills. The Northwest Territories EPA does not include a civil cause of action, but we are flagging the civil cause of action as this is something that could be added to the NWT EPA in the future. There are a couple of relevant civil claims decided under the Ontario EPA statutory cause of action. The first we'd like to discuss is Midwest Properties Limited versus Thordarson at the Court of Appeal, decided in November of 2015. In Midwest, the Ontario Court of Appeal awarded damages for restoration of petroleum hydrocarbon contaminated property under this never before applied section in the EPA, the civil cause of action, section 99. Section 99(2) says that any person who has the right to compensation for loss or damage as a direct result of a spill of a pollutant from the owner of that pollutant and the person having control of that pollutant. Briefly, the facts are that Midwest had obtained a phase 1 environmental site assessment of the property prior to purchase and was advised that further investigation wasn't required. Midwest later discovered that contaminants had migrated onto its property from the adjoining property owned by Thordarson. Thordarson had operated his waste oil bulking business for decades prior to Midwest's purchase. The court said that restoration damage award approach is superior from an environmental perspective to the diminution in value approach. Midwest was awarded the cost to clean up plus punitive damages because Thordarson had failed to comply with the ministry cleanup order. From a real estate perspective, Midwest raises a question about the effectiveness of Midwest's pre-purchase due diligence. Thordarson was Midwest's neighbor at the time of the purchase. So we wonder what Midwest Consultants report said about that neighbor and their activities. Another point to remember is that damages are awarded for the cost of remediation, but the court, the damages were awarded for the cost of remediation, but the court didn't address diminution in value because no evidence of diminution was brought. Because of that, our view is that Midwest does not close the door on a diminution award. Defendants will frequently argue that diminution damages are appropriate because the quantum is often less than remediation. We think this still could be an appropriate case to make. So one last case for me before turning it back over to Chuck is Huang versus Hillary. This is another, in July of 2018, the Ontario Court of Appeal released its decision in Huang. The decision addresses some questions about statutory cause, the civil cause of action that were unanswered in Midwest. Huang focused on the application of the Section 92 provision that occurred for a spill prior to 1985, before Section 99 sub 2 was proclaimed in force. Here are the facts of the case. Huang purchased a property in the 70s. In 2002, Huang wanted to redevelop and conducted a phase 1, phase 2 environmental site assessment. The phase 2 environmental site assessment revealed concentrations of dry cleaning solvent in the soil and groundwater above ministry standards. Hillary's company had operated a dry cleaning business at the neighboring property since 1960. Huang sued the Hillary company and Mr. Hillary personally, but not as the manager or controller of the dry cleaner, rather as the owner of the abutting property. The Hillary company argued that it wasn't liable under Section 99 sub 2 because Section 99 sub 2 does not apply retroactively. In Huang, the trial court found the application of Section 99(2) to historical spills was prospective. The trial court said Section 99 sub 2 enables a right to compensation at this time or in the future for loss or damage incurred as a direct result of such spills. That is, the right to compensation for spills can occur at any time, whether the spill occurred before or after proclamation of the act, of the section. The court added that even if Section 99 sub 2 was not prospective, the application of 99(2) to historical spills is still valid because the purpose of the EPA and of Section 99(2) is the protection of the public. The Supreme Court of Canada has established that where a provision is intended to protect the public, rather than punish the appellant for past conduct, then the presumption against retrospective operation of statutes does not apply. The attention of the legislation to compensate for spills, including historic spills, rebutted the presumption against retrospective application. Mr. Huang was awarded the cost to clean up plus his out-of-pocket costs. Both plaintiff and defendant appealed, and the appeal court upheld the trial judge's decision and damage award. Hillary sought leave from the Supreme Court of Canada. Leave was denied on April 11, 2019.
So the last topic we want to touch on today is regarding climate change, potential climate change liability. Directors and officers' responsibility and liability for climate change related issues seems to be an emerging trend. Investors are continuing to closely track climate change disclosure and associated corporate governance practices. Inadequate disclosure of climate change risk, coupled with a lack of good governance, could expose corporate directors and officers to liability. As you know, climate change risks include physical risks, extreme weather, shifts in climate patterns, as well as transitional risks, changes in the markets, regulations, policies, technologies related to a shift towards a low carbon economy. Given the potential risks and liabilities associated with climate change, Investors may seek to hold corporations and their directors and officers accountable if corporate disclosure respecting climate change risks, opportunities, financial impacts, and corporate governance related to climate change are seen as inadequate. For example, in the United States, a case called Ramirez and Exxon Mobil Corporation, an investor filed a securities fraud class action against the company and 3 of Exxon's officers in the federal court in the North District of Texas. The claim alleged that Exxon's public statements made during the period February to October 2016 were materially false and misleading. The class action further alleged that 1, Exxon had failed to disclose climate-related risks. 2, it had used an inaccurate price of carbon to calculate the value of certain oil and gas prospects. And 3, as a result of Exxon's disclosures, the common stock price was artificially inflated. Exxon brought a motion asking the federal court to dismiss the class action. Exxon argued that the disclosure was not false or misleading and that the claim did not adequately plead fraudulent intent or loss of causation. The federal court allowed the claim to proceed against Exxon. Exxon brought a subsequent motion, and that too was dismissed. The case is ongoing and could have important implications for directors and officers both south and north of the border, particularly if the plaintiffs are successful. Apart from potential civil liability, large-scale investors can decide to pull investments where they conclude that corporations have not adequately addressed climate change-related risks, or investors can ask difficult questions of those corporations. For example, ahead of Rio Tinto's annual meeting several years ago, some investors tabled a shareholder motion to improve the mining company's weak climate goals. Rio Tinto had announced that its indirect emissions from generation of purchased energy such as electricity would be 15% lower by 2030 compared to 2018 levels. Proxy investor Institutional Shareholder Services, ISS, recommended that shareholders should support a further resolution asking Rio Tinto to tackle emissions generated by its customers through the use of its products. ISS noted that shareholders have a long-term interest in assessing whether Rio Tinto is adequately assessing and acting on its climate risk and opportunities. In August 2019, the Canadian Securities Administrators released Staff Notice 51-358 to provide guidance to corporations about climate change-related risks dealing with reporting. The notice provides guidance on several issues, including 1, assessing the materiality of climate change-related risks, the types of climate change-related risks, voluntary disclosure requirements, and forward-looking climate change-related information. Lenders and other organizations are also relying on internationally accepted standards to provide guidance on the development of disclosure. For example, the Task Force on Climate Change-Related Financial Disclosure recommendations provided that disclosure should include 4 themes. 1, governance, the organization's governance structure around climate change-related risks, as well as opportunities. 2, corporation strategy, the actual and potential impacts of climate-related risks and opportunities on an organization's business, strategy, and financial planning. 3, risk management, the process by which the organization identifies, assesses, and manages climate-related risks. And lastly, metrics and targets to assess, manage relevant climate change-related risks and opportunities. Investors are also becoming increasingly concerned with good governance in relation to this issue. Directors, as you know, have a duty of care and must exercise care, diligence, and the skill of a reasonably prudent person in comparable circumstances. There are provisions under the Canada Business Corporations Act, as well as the Northwest Territories Business Corporations Act, covering this requirement. Directors also have a fiduciary duty to act in the best interests of the corporation. Again, sections in both acts are there. In 2019, the CBCA was amended to add environment and the long-term interests of the corporation as factors to consider. While the NWT legislation does not specifically list environment and long-term interests of corporation as factors to consider, diligent directors will want to consider and assess the risks that climate change could pose to their businesses, and thereby ensure compliance with their fiduciary duties. Ensuring good governance may require directors to look to establish frameworks for best practices, such as the principles of responsible investment or the United Nations Guiding Principles on Business and Human Rights. These principles may impact the fiduciary duties that directors and officers owe to their shareholders. Bearing in mind these principles, boards of directors should consider 5 key questions when assessing best practices relating to climate change. 1, does the board have a climate change plan to identify and manage climate change related risks? 2, does the board have effective oversight of its climate strategy, including identifying climate-related risks that are emerging? 3, has the board identified strategic opportunities to address climate-related risks over the short, medium, and long term? 4, who in the company is responsible for climate-related risk and implementing the company's climate strategy? And 5, is the board reviewing and approving the disclosure of the company's efforts to manage climate change? So we've covered a lot of ground today, but it's clear that for directors and officers, managing environmental liability is an ongoing challenge. And climate change disclosure and governance could be the basis of a new wave of liability for corporate directors and officers. We continue to say that the best way to manage and mitigate environmental risk is to anticipate that risk and actively manage and make a plan to manage it, or to avoid such risk if possible. Again, this is best done through the development of a company-specific environmental management policy, with procedures and programs to backstop that policy. Such policies, procedures, and programs should be in writing and regularly reviewed to keep pace with industry standards. Tell your clients that there are steps that they can take to enable them to do their deals and to manage their potential exposure to environmental liability. Telling your clients about environmental management is the single most important ticket to assisting them to be able to accept and manage environmental risks that are part of almost any transaction these days. Thanks for listening to us. Any questions, Glenn?
Thanks, Chuck, and excuse me, and thanks, Julie. We don't have any questions yet. Let's just wait a couple of minutes, and if any of you who are on the session have any questions, just send them through the chat function. I'll remind everyone again that Chuck and Julie have provided us with a pretty extensive list of articles and the cases that they've referred to, and we'll be circulating that to everybody who registered for this session. We'll also be putting that material up when we put up the recording of this session on the Law Society's YouTube channel.
Yeah. While we're waiting, I just wanted to go back to industry standards. So in my part of the world, there has been a lot of scrutiny about the soil erosion and sediment control procedures where there are construction projects, and it's the erection of making sure that you've got proper settling ponds, you've got proper silt curtains and check dams to prevent sediment getting into water bodies and the erosion of soil on shorelines. And it got to the point where my practice was involving the defense of a number of construction companies. One in particular was getting repeatedly charged and fined. They got to the point where they decided to hire the guru on soil erosion and sediment control from the U.S. Environmental Protection Agency, and he came up, and over the course of a number of days, the company developed a detailed plan for managing soil erosion and sediment control. It literally was a binder that was almost as thick as their occupational health and safety procedures. We went to the local environment district office. We sat down with the folks there, walked them through the plan, and they said, this is excellent. This is exactly what you need. And in fact, a week later, there was a weather burst and soil and sediment was discharged into a water body, and the company wasn't charged because it was shown to have implemented these procedures that were in the binder. Having said that, it's become a bit of an industry standard. So when other companies haven't provided that kind of response to soil erosion and sediment control, the ministry is very quick to remind me and others of this particular binder that's sitting on the director's shelf showing what needs to be done. So once you start down that road, you really have to keep at it. Otherwise you can get, others can get dinged because that's the industry standard, or it hasn't been updated on a regular basis.
Thanks for that. All right, I'm not seeing any questions. So then what I'm going to do is, whoop, just a sec.
Somebody's phoning in a question.
Yes, somebody's phoning in a question to me, it appears. What I'm going to do.
Why do you have these guys on for such a long time?
Yeah, no. What I'm going to do is I'm going to close the session down. Thank you again, Julie and Chuck, for all the information. Those of you again who are interested in the cases and other articles that Julie, Chuck, and others at Willms and Shier put together, we'll get that information out to you either tomorrow or early next week. Again, thanks to all of you.
Take care, everybody.
Thanks.
Bye-bye.